The moment you click Agree on a new app update, you may be instantly surrendering a fundamental constitutional right. The legal threat of forced arbitration clauses in consumer contracts is quietly rewriting the rules of justice, stripping away your access to the public court system. This is not a hypothetical scenario reserved for high-stakes corporate litigation. It is an active daily forfeiture of your legal autonomy hidden behind a wall of digital text. A forced arbitration clause is a legally binding provision buried deep within a contract that mandates any dispute between you and the company must be resolved in a private, out-of-court proceeding. Instead of presenting your case to a judge and jury, a private arbitrator decides your fate. By merely using a streaming service, opening a bank account, or unboxing a smart device, these digital agreements assume your absolute consent to bypass the public justice system entirely. The immediate consequence of this silent mechanism is the complete neutralization of your leverage against massive entities. If a corporation suffers a catastrophic data breach, exposing your financial records, or if they illegally harvest your biometric data, you cannot take them to a public court. More alarmingly, these provisions almost universally include a class action waiver, legally barring you from joining forces with other victims to hold the negligent entity accountable. This systematic isolation transforms massive corporate liabilities into minor, manageable expenses for the offending companies. When millions of users are wronged by a fraudulent fee or a severe privacy violation, the damages are staggering in aggregate. But individually, they might only amount to $20. Stripped of the ability to file a class action, the mathematical reality dictates that almost no single consumer will spend thousands of dollars in private fees to arbitrate a $20 claim. The foundation for this widespread disenfranchisement traces back to the Federal Arbitration Act, passed in 1925. Originally, Congress designed the Federal Arbitration Act to facilitate dispute resolution between merchants of equal bargaining power, allowing two businesses to settle shipping or inventory disputes without clogging the public courts. It was never intended to be a weapon wielded by monolithic tech conglomerates against everyday citizens clicking a screen. Over the decades, aggressive legal engineering mutated the original intent of that century-old law into an impenetrable corporate shield. Defense teams recognized that if they could force every consumer dispute into a private room, they could effectively immunize their clients from public accountability and massive jury verdicts. This deliberate distortion paved the way for the modern crisis of consumer disenfranchisement we face today. The Supreme Court cemented this vulnerability in the landmark 2011 ruling AT&T Mobility LLC versus Concepcion. In a sharply divided decision, the court ruled that the Federal Arbitration Act preempts state laws that previously banned class action waivers in consumer contracts. This ruling effectively declared that corporations have a federally protected right to ban consumers from banding together, superseding local consumer protection statutes across the country. The fallout from the Concepcion decision was immediate and devastating to digital and financial autonomy. Companies across every sector, from telecommunications and banking to streaming services and gig economy platforms, rushed to update their terms of service. The ruling provided a judicially endorsed blueprint for companies to rewrite the rules of engagement, ensuring that any future legal battles would be fought strictly on their terms. This judicial trend continued to expand, crossing from consumer protections directly into the workplace. In the 2018 case, Epic Systems Corp. Versus Lewis, Supreme Court rulings affirmed that employers could also use these clauses to prevent workers from forming class actions over wage theft and labor violations. The boundary of this legal trap widened significantly, capturing not just what you buy or download, but how you earn a living and survive. Understanding the private arbitration system itself reveals exactly why corporations fight so relentlessly to keep you trapped within it. Arbitration firms are private businesses, and their primary clients are the massive corporations that write them into millions of consumer contracts. While arbitrators are bound by ethical guidelines, the structural reality is that a private judge who consistently rules against a major corporation may find themselves rarely selected for future lucrative disputes. Beyond the inherent structural bias, the most dangerous element of this shadow system is its absolute secrecy. Arbitration proceedings are highly confidential, producing no public record, no media oversight, and no binding legal precedent for future victims. When a company is caught illegally tracking user location data, a private settlement ensures the methods of that privacy violation remain completely hidden from the public and regulatory agencies. This enforced silence acts as a dark matter within the legal system, swallowing evidence of systemic corporate abuse. Because no public precedent is established, a company can face the exact same accusation of data mishandling from 1,000 different consumers and fight each one in a vacuum. The secrecy guarantees that corporate misdeeds are treated as isolated incidents rather than widespread actionable threats to public security. For the individual navigating this hidden landscape, The emotional and financial toll is meticulously designed to be prohibitive. The filing fees for arbitration, while sometimes subsidized by the corporation, are just the beginning of a complex, jargon-heavy process that heavily favors the party with an army of corporate lawyers. The system is engineered to induce fatigue, encouraging you to abandon your claim before the proceedings even begin. However, the legal battlefield is constantly shifting, and consumer advocates recently discovered a pressure point in the corporate armor known as mass arbitration because companies drafted these clauses to force individual proceedings and obligated themselves to pay the initial filing fees for each one. Coordinated campaigns began filing tens of thousands of individual claims simultaneously. This tactic suddenly threatened corporations with millions of dollars in upfront fees. The corporate response to this vulnerability was swift, ruthless, and entirely predictable. Realizing their own shield had been turned against them, companies began rewriting their terms of service yet again, this time creating convoluted batching processes for mass claims or attempting to force consumers into entirely new, untested dispute resolution platforms. The goal remains the same, to continuously alter the digital contract to ensure the consumer never holds the advantage. At the core of this ongoing conflict is the severe erosion of the Seventh Amendment, which guarantees the right to a trial by jury in civil cases. While the courts maintain that agreeing to arbitration is a valid waiver of this right, the reality of modern digital life makes true consent an absolute illusion. You cannot participate in modern society without a smartphone, a bank account, or internet access, all of which mandate this constitutional surrender. Legislative pushback has yielded narrow but significant victories, proving that this legal trap can be dismantled with enough political will. The Ending Forced Arbitration of Sexual Assault and Sexual Harassment Act of 2021 amended the core federal law, invalidating these clauses for specific, severe claims. This bipartisan legislation demonstrated that Congress recognizes the inherent injustice of forcing victims into secret tribunals, establishing a critical precedent for future reform. Despite that targeted victory, the vast majority of digital and consumer rights remain fully exposed to the arbitration trap. If a tech giant harvests your biometric data without consent, or a credit bureau fails to secure your financial identity, the 2021 amendment offers absolutely no protection. The broader shield remains fully intact, leaving your data privacy, consumer rights, and financial security locked within the private system. The broader legislative solution currently stalled in Washington is the Forced Arbitration and Justice Repeal Act, known as the FAIR Act. This proposed legislation seeks to comprehensively ban forced arbitration in consumer, antitrust, employment, and civil rights disputes. While it represents the ultimate defense strategy at the federal level, intense lobbying efforts from corporate conglomerates have consistently prevented it from becoming the law of the land. While Congress debates the FAIR Act, the daily reality for consumers is a landscape fraught with hidden legal traps that require constant vigilance. Every new account creation, every software update, and every digital purchase is an opportunity for a corporation to quietly update their terms, tightening the legal constraints around your autonomy. Waiting for a legislative rescue is not a viable strategy for protecting yourself today. Reclaiming your legal autonomy requires immediate, proactive vigilance every time you engage with a new digital service or financial product. The first line of defense is auditing the contract before you click accept. You must actively search the terms of service for specific headers, typically labeled dispute resolution, arbitration agreement, or class action waiver. Identifying the threat is the mandatory first step before you can deploy a countermeasure. Once identified, you must look for the opt-out provision, a narrow escape hatch, hidden in a fraction of these modern contracts. Many companies attempting to make their clauses appear less coercive to federal judges include a 30-day window from the date of account creation to reject the arbitration agreement. This usually requires sending a specific email or a physical letter stating your explicit refusal to be bound by that specific clause. Executing this opt-out requires precise documentation to ensure your legal standing is preserved if a dispute arises. If you send an email, archive the sent message, the exact timestamp, and any automated reply. If you send a physical letter, use certified mail with a return receipt. If a corporation later attempts to force you into a private tribunal, this meticulously preserved paper trail is your only shield to prove you retained your right to court. If the 30-day window has closed, or if the contract lacks an opt-out provision entirely, your next tactical move is to locate the small claims court exemption. Most forced arbitration clauses explicitly state that either party can still pursue individual claims in a local small claims court. While this does not restore your ability to join a class action, it keeps your dispute in the public justice system, preserving your leverage for smaller financial or privacy violations. The unchecked proliferation of forced arbitration clauses is a deliberate, systemic campaign to sever your access to the public justice system. While this information is for educational purposes only and not legal counsel, understanding the mechanics of this threat and tracking the Supreme Court rulings that enable it allows you to stop being a passive subject of corporate policy. Your legal autonomy is not something they can take if you know exactly how to guard the gate. Vigilance in the digital age requires reading the fine print before it dictates your future and limits your freedom. You have the tools to identify the trap, document your dissent, and preserve your constitutional rights against corporate overreach. Exposing hidden legal threats transforms vulnerability into true empowerment, ensuring you are never locked out of the justice system. Follow for more legal clarity.